like to welcome you to From Life to Life, an informative morning of seminars and lectures on planning for our future. We have an all-star lineup of presenters that are coming up, and without further ado, I'd like to introduce our first one. Mr. Phil Roithman is a certified specialist in estate planning, trust, and probate law, and he's actually assisted many members of our community already with planning their end-of-life matters from a legality and paperwork perspective, and all of those things. So without further ado, I'd like to introduce him. He's going to be talking about, of course, estate planning, why it's important, and what to expect. Phil will talk for about 20 minutes, and then afterwards we'll open it up for a 10-minute Q&A. Again, we're departing a little bit from the schedule on the schedule in front of you, and that's because Phil has to leave, so he won't be around for the Q&A with everyone, but at least we'll get a chance to pick his brain. So without further ado, ladies and gentlemen, Phil Roithman.
Thank you, Zushi. Welcome, everybody, and thank you for inviting me. It's a real pleasure to be here. And thank you for accommodating my schedule. You know, life happens, as they say, and so, you know, we got to be in 6 different places at once. But anyway, I'm really glad to be here, and, you know, I have about 20 minutes to talk. We'll do some questions and answers. You know, obviously I can only touch upon a few things, but you know, just quickly about me, I'm, as she said, a certified specialist. I'm an attorney in estate planning, trust, and probate law. I've been in private practice for about 24 years, and the last 16 of which I have my own firm in Montrose, Glendale, California, just focused on estate planning and anything that comes under that umbrella. You know, I joke because I have a lot of clients who kind of procrastinate about doing their estate plan, and I used to work for an attorney in Atlanta, and he used to say to the client, he'd say, well, you know, you tell me the day before you're going to die, and we'll do your trust, you know, so I always, you know, kind of make it a little bit lighthearted, but, you know, I start with the definition of what is estate planning, and it's really, to me, about maintaining control. So if you become incapacitated, how do you maintain control over your property, your healthcare decisions, your assets? And then when you pass away, how do you transfer what you own to your beneficiaries, to the people you want to, when you want to, in the manner you want to, and to do all of this with the least cost, whether it's court costs, taxes, probate, delays, anything like that. So in other words, a smooth transition of your assets, your wealth, to your beneficiaries when you pass away. So that's kind of in a nutshell what estate planning is all about. And it's also about protecting your beneficiaries. And we do a lot of planning on, well, I have a child who's got special needs, or I have a child who's got substance abuse issues, or a beneficiary. How do I protect what they're going to receive? Or they get certain government benefits. How do we make sure we don't jeopardize those benefits? So it's just, you know, very important to take a holistic approach to estate planning and really find out, you know, what the client wants, what the client needs. That's kind of like the second part of what you know, what the topic is, what to expect. And what to expect is, you know, having a meeting and me finding out about your situation. What are your unique needs, goals? And everybody's, you know, estate plan is different, and I like to say, why is it important? Well, everybody has an estate plan, whether you create one with an attorney, or if you don't, the state of California has an estate plan for you, which you may not like. So that's why, you know, it's very important, because you've heard a lot of stories in the news, especially if a celebrity passes away, and they haven't done a trust, or they haven't done a will or something like that. Of course, there's a big fight, and, you know, property often ends up going to unintended beneficiaries. You know, I used to do a 2-hour seminar, and I talked a lot about, you know, people like Marilyn Monroe or James Dean, and they died without a will, and property went, like James Dean was estranged from his father, he didn't have a will, everything went to his father, because that's what California law says where it goes if you don't have any children. So, you know, that's why it's important to be proactive, to take steps to do an estate plan. And so, there's a lot of common, estate planning strategies or techniques. People will set up their assets and property as joint ownership with somebody else. It's kind of, we call that a poor man's or a poor person's estate plan. In other words, you don't have to go to a lawyer. You can set up a bank account with a joint owner and say, when I die, it goes automatically to the other owner. Or when I die, it goes automatically to a beneficiary. Yeah, that works, but it's probably lacking in some other features. But people do that frequently. They may gift property during their lifetime and say, oh, I want to give it to somebody anyway, I want to leave it to them when I pass away, so I'm just going to give it to them during my lifetime. There are some potential tax drawbacks to doing that. I won't get into it, but there's some actual advantages if you intend to have somebody receive your house or your investment account when you pass away. All else being equal, it's better to let it pass at your death because the property gets a new income tax basis. You can save a lot of capital gain taxes. That's the bottom line. So people say a lot of the time, oh, I want to give this property to my children now, and we have to think about what are the ramifications. Is that going to cost you income taxes by paying capital gains today, or when the beneficiary sells it rather than waiting until death? What about property taxes? Anytime in California you transfer real estate, whether you own it directly or whether you create maybe an LLC to own a rental property, anytime you do anything involving real estate in California, it's like the light goes on. What are the property tax consequences? Because they can be very significant if you're not taking that into account. So, having talked about what are some of the reasons we do estate planning and what we want to accomplish, we find that in California and in many other places, a revocable trust, a revocable living trust, same thing, is frequently the centerpiece of somebody's estate plan. And the question is why? Because it does all the things we generally want to accomplish. It can provide for successor trustees to manage your affairs. If you become incapacitated, you don't have to go to court to get a conservatorship, which is very public and time-consuming and expensive. And so a trust is for incapacity planning, and again, also when a person passes away, the trust can be designed. We design the trust so, number one, if the client is married, the property remains in the trust for the benefit of his or her surviving spouse. And then when both spouses pass away, the property can be distributed to their intended beneficiaries. And again, there's ways to design the trust so that if the client is concerned this beneficiary, again, is a spendthrift or is not responsible, we can protect the beneficiary from what I call creditors and creditors, from people who may want to try to take advantage, and we can design the trust so that the property remains in trust for the beneficiary, but it's protected if the beneficiary ever gets sued or gets divorced. So we have all these issues that we discuss with the client, and so a revocable trust is typically the centerpiece of somebody's estate plan. And so we talk in general when we meet with clients about designing the trust and who they want to benefit. And of course, charities are often an important part of somebody's estate plan, and I work with a lot of clients as part of their trust to name charities, but I also do some standalone planning, creating charitable trusts that the client can set up during their lifetime, where maybe they give property to a trust, that they receive the income from that property, but when they pass away, they've designated a charity, Calvada Pasadena, for example, and the property passes to the charitable beneficiary when they pass away, and that also provides some income tax benefits. So we have many tools in the toolkit. I do a lot of planning for, as I said, clients with special needs or with children with special needs. That's a whole other very sophisticated area of planning, and the rules are constantly changing in that area. So if a client is receiving Medi-Cal or social or SSI, certain government benefits, it's very important that we make sure that whenever they get an inheritance, that it's not counted as a resource which could potentially jeopardize or eliminate those benefits. And especially the rules for SSI from the Social Security Administration, they remain relatively stable, but the Medi-Cal rules literally are just changed because there was a new budget passed. So Medi-Cal used to have an asset limit that a beneficiary couldn't have more than $2,000. Then it was changed to $130,000. Then there was no asset test, and now the asset test for $130,000 is being implemented again. So we have to be very nimble when we're doing estate planning. We have to be aware, I have to be aware of all the changes in the law and be able to respond accordingly. So it's really important if you have beneficiaries or people that you want to include as part of your estate plan, and if they are, you know, somebody who's getting certain government benefits, that you have to be able to you have to mention that. You know, we want full disclosure. You know, it's very important when I talk to the clients that they tell me everything about their situation so we can, you know, cover all the bases. So that's a very important planning, part of my planning. And so, I mean, there's a whole lot more I could get into, what to expect. Let's see. Yeah, we talked about protecting beneficiaries from, you know, from potential creditors and predators. And, you know, I think that's a good overview of everything that I really wanted to cover. I mean, I could talk a lot about other things that, you know, are important to consider, but I'm happy to open it up to questions if you have questions, and we can just use the rest of the time for that. So let's just start right here.
Yeah, do you can assign an executor if there's nobody that can, if the person doesn't have anybody in order to execute?
So you're saying, I think you asked, can I serve?
An executor.
So the question is, you know, can you name your attorney? So that's a very good question. I have a lot of clients who, for whatever reason, they don't have a, so let's take a step back. So when a client creates a trust, typically they're wearing a few different hats. They're the creator of the trust, which is what's called the settlor. They are also managing the trust, called the trustee, and they're also the beneficiary. But we have to have typically backup people if they can't serve as trustee. So the question is, who should I name? Sometimes clients really don't have children or family members, so there's a couple of other choices. Number one, they can name what we call a professional fiduciary, so individuals that are licensed by the state of California to serve as trustees, as executors, as agents under powers of attorney. And so that's another option. I have occasionally, when really there was no other really good options, I've allowed clients to name me as their successor trustee, so I do it. I don't like to do it as a general rule, but I have done it in a few limited cases. And I guess the other thing I would mention, because you triggered something else I thought about, so I talked about doing a trust typically as part of a client's estate plan. It's also really important to do what I call ancillary documents. In other words, we do a will. Somebody may be thinking, well, Phil, what about a will? Well, a will is important, but we do what we call a pour-over will. So it basically coordinates with the trust, and it's there as a safety net. So we want to transfer assets appropriately to the trust, and we call that funding the trust. So in other words, if I draft a trust, I can draft a beautiful document, says all the right things, but if we don't fund the trust, if we don't transfer title to your home to the trust, or retitle bank and investment accounts in the name of the trust, we really haven't accomplished anything. We have a nice document, but the trust has to be funded. So it's important to fund the trust. That's usually what I call the second phase of doing the estate plan, but to also create healthcare powers of attorney to enable people to make healthcare decisions if you're not ever unable to do so. powers of attorney for financial matters, and that would cover things like anything that's not part of your trust. So you have trust and trust assets, and then you have powers of attorney. What if somebody needs to do business on my retirement account, or file my tax returns for me, or call the Social Security Administration to find out what happened to my check last month? The first question they're going to ask is, who's got a power of attorney that authorizes somebody else to get this information and to talk to us? Yes.
We have a living trust. We had it done like 20 years ago. They gave us this huge notebook, to fill out. And I heard that we have to update it. Like we wrote in it 20 years ago. It's basically everything's the same that we want. But do you have to update them?
Excellent question. What about reviewing the trust? So what I tell, and that triggered something else I wanted to mention briefly. So I usually advise clients that they should review their trust every 2 or 3 years, unless there's a big change, let's say either in the law, the tax law, for example, or change in your circumstances. Maybe you got divorced, you got married, you had a child, etc. So whenever there's other changes or changes in the law, or every 2 or 3 years. So for clients like you that have older estate plans, what I have found is that those plans have certain provisions in them that made sense when the trust was drafted, especially in terms of estate taxes, and I'll mention that in just a moment. And so it made sense when the estate tax exemption, in other words, the amount that you could transfer to your beneficiaries without paying any estate taxes, was about $1 million. Well, if you own a house in California and any other kind of, your estate's more than likely over that. The estate tax, so it was drafted a certain way, which made sense, but it's a very rigid way, and it actually has some disadvantages. So when clients come in and I see a plan that said, okay, basically it says when the first spouse dies, we're going to split this trust into maybe 2 or sometimes 3 separate trusts because we want to save estate taxes, etc. That really no longer makes sense. Why? Because the estate tax exemption has been and now is, quote, permanent, as long as, the law doesn't change. That's what permanent means in my world. But the estate tax exemption is $15 million under the Big Beautiful Act that was just passed per person. So a married couple can transfer $30 million free of estate taxes, so that those older plans that have language that was put in place when the exemption was $1 million really should be reviewed and perhaps updated. So that's an excellent question.
And do you do that if they're made appointment and brought in?
Yeah.
Okay.
Yeah, sure. And I'll mention also, just because I think it piggybacks that, so a pretty good part of my practice, maybe I'd say 20%, is what I call trust and estate administration. So after somebody passes away, how do we administer the trust according to the terms of the trust? In other words, and whoever asked about trustees, that's the trustee's fundamental job, is to make sure that they follow the terms of the trust. They have to do that in order to fulfill their fiduciary obligations. So a big part of my practice is trust administration, advising trustees. Sometimes it does involve filing court petitions when, for example, somebody had an older type of trust that really doesn't work anymore. Actually, in California, even though the trust is, quote, irrevocable in California, we can actually go to court and modify an irrevocable trust. And that's great. I've probably done a court petition like that maybe 25 or 30 times to get a better result for the client.
Thank you.
And so the answer is yes.
Yes, thank you.
Yes.
2 questions. One, about the state of California, have they paralleled that exemption and how does it affect your trust planning? And the second thing I heard that many of the banks are saying, I've had some friends this happened to, that your power of attorney can't be over a certain number of years old. So even if your trust is okay and doesn't need to be modified, you just need to almost just reissue it every so many years, 2 or 3 years, because they found that people forgot they had some power of attorney, and so the banks didn't want to be liable from there. I don't know if you've seen that, but I've seen that with some of the major banks.
Excellent, that's a great point. The first point I think you're asking about is what about California's estate tax? Well,
Right.
California, we don't have an estate tax, so we don't have to worry about. Other states do, so I have clients who might move to Oregon or wherever. Other states do have exemptions that are much lower, that are $1 million or $2 million, so there definitely has to be coordination, but we don't have to worry about that in California. The second question, you raised an excellent point, which really goes to funding the trust. Okay, so the question was, banks essentially not honoring legitimate, valid, legal powers of attorney. And it happens a lot, I hear it a lot, and I've experienced it. So the issue there is you have a bank account that's not part of your trust. Maybe it's got $10,000, it's a smaller value bank account, and somebody says, okay, I don't really want to transfer that to the trust. My general recommendation is for any non-retirement assets, because retirement assets are a whole other category. Typically, you name beneficiaries on your retirement accounts. They pass outside the trust. So any assets that you can have a beneficiary, or life insurance, or IRAs, or 401ks, where you name a beneficiary outside the trust. But what if you just have a bank account, a CD account for $10,000, and it's not part of the trust? How do you authorize somebody to renew that CD or make a withdrawal if you're in the hospital or something? The answer is with a power of attorney. But as you have pointed out, for whatever reason, banks are sometimes skittish about honoring powers of attorney, especially when they're older. So that's a very valid point, and that's why when clients say, how do I really have to transfer this $3,000 account or a small account to the trust? My general recommendation is yes, to avoid that issue.
And then the bank has to honor the trust, even if the person has passed away and you have a power of attorney. If you're the trustee, you're good, right?
Well, first of all, just to clarify, powers of attorney when somebody dies are no longer valid. They're only valid during somebody's lifetime.
Yeah.
But we're talking about a situation where somebody's alive
Right.
and you want to do something, instead of the power of attorney, which banks may or may not honor, if the asset was part of the trust, banks are very familiar and work with trusts and trustees all the time, especially here in California. So I think
Thank you.
Yeah, the age, when you think about your people who are gonna have the power of attorney, they should be younger. I mean, when you think about it, if you're old, and you pick somebody older, will they be able to make those decisions?
Well, not necessarily, but it's a factor to consider. So you always, whenever you name either trustees and successor trustees, and it's important to name a successor, usually one or a second backup alternate for any of the people that you name in your estate plan, whether it's trustees under the trust, agents under powers of attorney for financial matters, agents under healthcare agents when you set up advanced healthcare directive or medical healthcare power of attorney. So always, that's why I generally suggest, okay, you have one person, but then have a backup, or sometimes multiple backups.
Is it the new asset test for California for medical is 130,000?
130,000, yes.
So if they're 130,000 or lower, they still qualify for everything, all benefits, or some yes, some no?
So we're talking in general about qualifying for Medi-Cal.
Medi-Cal.
All right, so basically Medi-Cal always had an asset test, which was you couldn't have more than $2,000 in your individual name. If you had a bank account or an investment account or something worth $2,000, Medi-Cal's asset test would say you don't qualify for Medi-Cal. Medi-Cal also has income limits that go to share a cost and things like that. So the asset test was gradually phased out over the past few years. It was raised to 130,000. It was then eliminated a few years ago, but under the last budget that was just passed in this month, I think, the 130,000 is being phased back in. So somebody who applies for Medi-Cal, including whatever benefits Medi-Cal offers, whether it's IHSS and home supportive services or anything else, if you don't, you've got to now look at that asset test again. And how do you work around that? There's strategies. You can gift giving way, you can create a special needs trust. I mean, there's other strategies, but the asset test is gonna be implemented again. I think it's January 2020.
So that 100,000 or less, it's still qualified.
Yes. I mean, assuming you otherwise qualify. Yeah.
That's as of January 1st.
I believe that's the implementation date. I'm fairly certain, but it's, they have to give it some time before they can implement it. Yeah.
And if you use your house for.
Yes, house is generally what we call an exempt asset, and we apply for Medi-Cal, it's just not. Yes.
Could you recommend a good, reasonably priced lawyer who can help with writing wills and?
Phil, let me reframe the question. Do you have cards here with you? And I guess on a related note, do you have a max amount of clients that you're looking? I assume you're not constantly taking on. Can you take on a whole bunch of clients? Are you referring to other people? If you can handle it, do you refer to other people? Like, what's your
Yeah,
talk
so
a little bit about that.
I accept new clients. I have a lot of colleagues that for whatever reason I'm able to take on a case. Maybe there's a case that's, I don't do any trust or estate litigation. So for example, if somebody comes to me and says, we have a potential situation where there's conflict, there's disagreement among beneficiaries, I don't do that. So I have colleagues who do that stuff for me. But I take on new clients, and generally, and I have a few cards I can leave. Usually I'll meet with a client for an hour, and in the last few years, we give a lot of options for Zoom calls, for phone calls, for in-person, whatever works. It's an hour complimentary consultation. I have a very brief questionnaire I provide to the client so we can have a productive meeting. And at the end of that meeting, I do all of my estate planning for fixed fees. So at the end of the meeting, I say, here's what my fee is to do the plan, which includes if we have to transfer title of a house or a property to trust, includes that aspect of funding. And that's how it works, and I find most clients like that. Yes? In Montrose, technically my address is Glendale, but it's basically Montrose, right? Yeah, so my address is 2013 Broadview Drive, Glendale. My office number, if you want to jot it down,
Yes.
share that, is 818, very easy, 818-369-7676.
All right.
818-369-7676. And my email, also you can communicate with me by email, it's Phil, P-H-I-L, at, and then it's my last name, Roitman, R-O-I-T-M-A-N, lawoffice.com. Phil at RoitmanLawOffice.com. So feel free to call if you just want to ask a question, whatever it might be. I'm happy, always happy to answer questions and help you figure stuff out. Yes. Yes.
I'm not on it, but there is such a thing as long-term care.
Yes.
I have that, if I have to
Mhm.
have that. And then Medi-Cal covers something like that, like they used to have that limit, right? Are you
Correct.
saying now the limit is more than that, or you may own before you couldn't own your house, you couldn't own anything?
No.
$2,000.
Okay, so quickly, a house is exempt. The house never counted. So when there was an asset test that said if you own more than $2,000, right, in non-exempt house doesn't count. House is fine. You can own a house. There used to be some rules where people transfer houses to trust that didn't apply anymore. So house is exempt, and as long as when you pass away, your house is in a trust, Medi-Cal can't do what they call estate recovery. People are, can they come and get my house? As long as it's in a trust, that's fine. So house is very easy to deal with, but the asset test is coming back, and so if you own more than, as of January 1, more than $130,000 in your name, you won't qualify. All right. Well, thank you so much for listening. Great question. Oh, one more question, and I've got to take your question. Per person. Yeah. It's per person, so one person's going to qualify, going to apply for Medi-Cal, so their assets have to be 130,000, yeah, or less under the new rules. Yes, that's an excellent question. So when married couples in California do trusts, we typically do what's called joint trust, although I do have clients, typically a second marriage, if they have assets from before they got married that they want to keep as separate property. So in California, as you know, we have community property, which becomes relevant either if you get divorced or when you pass away. So there are some clients who, second marriage, they have assets that they already own, they want to keep them separate. We might do a separate trust to hold those separate property assets, but for their joint assets, or if they're, a typical married couple, yes, we do a joint trust.
Okay, ladies and gentlemen, a big thank you to Phil. Thank you so much, yes, we'll leave these cards.
Sure.
We'll put them right here. For anybody who wants to take one on the way out, they're right here.